Please be seated. The sitting is resumed. I now call upon the delegation of the Netherlands to address the court and invite Mr. René Lefebvre to take the floor.
Thank you, Mr. President. Mr. President, distinguished members of the Court, it is an honor to appear before you today on behalf of the Kingdom of the Netherlands to participate in this hearing on the request for an advisory opinion on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. Let me express my sincere appreciation for this opportunity to speak early in this hearing, as the other participants have not had an opportunity to comment on our views in writing. The Kingdom would like to begin by underlining that, for the purposes of the present advisory proceedings, it leaves it to the discretion of the Court to satisfy itself that it has advisory jurisdiction and that it may exercise this jurisdiction with respect to the present request, in accordance with Article 65, Paragraph 1 of the Statute of the Court and Article 102 of the Rules of Court. The Kingdom would like to emphasize that it considers that, and I quote from the advisory opinion on the construction of a wall, the object of the request before the Court is to obtain from the Court an opinion which the General Assembly deems of assistance to it for the proper exercise of its functions, unquote. Therefore, the request should be regarded in a much broader frame of reference than a bilateral dispute. And it is with such broader frame of reference in mind that the Kingdom seeks to assist the Court in answering the questions contained in the request through the identification of the applicable international law and the presentation of the legal opinion of the Kingdom on the status and interpretation of that law. Mr. President, distinguished members of the Court, the Kingdom would now like to turn to the questions posed in the present request for an advisory opinion. Mr. President, according to the Kingdom, the right of self-determination of peoples is a permanent, continuing, universal, and inalienable right with a peremptory character. The principle of self-determination of peoples is enshrined in Articles 1 and 55 of the United Nations Charter. It is also contained in several resolutions of the General Assembly with historical importance, such as Resolution 1514, which states that, and I quote, "All peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue the economic, social, and cultural development." Unquote. The right of self-determination has been reaffirmed by the General Assembly in Resolution 2625, pursuant to which every state has the duty to refrain from any forcible action which deprives peoples referred to in that resolution of their right to self-determination. In addition, this right is enshrined in Article 1, common to the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. The Court has acknowledged self-determination as a right of peoples in the Namibia Advisory Opinion, the Western Sahara Advisory Opinion, the East Timor case, the advisory opinion on the construction of a wall, and the advisory opinion on the separation of the Chagos archipelago. In the East Timor case, the Court observed that the right of peoples to self-determination is a right erga omnes. The status of the right of self-determination as a right under customary international law is thus beyond reproach. According to the Kingdom, the right of self-determination is applicable in the colonial and in the post-colonial context. The right is, however, equally applicable to peoples under foreign or alien occupation, as confirmed by the General Assembly on several occasions, such as in Resolution 51/84 and its Millennium Declaration. It appears that the right of self-determination is a truly universal and continuing right. It applies to peoples under colonial domination, peoples residing in occupied territory, and peoples living in independent states. As a result, a state that occupies territory is under an obligation to respect and promote the right of self-determination of peoples residing in that territory. The obligation to respect and promote the right of self-determination means that, on the one hand, the occupying state shall refrain from measures that impede the exercise of the right of self-determination of the people concerned during the occupation, and, on the other hand, that the occupying state shall take measures aimed at creating the conditions under which the people concerned is able to freely and genuinely express its will in regard of its future political status. As the Kingdom has observed earlier, under international law, a distinction must be made between situations in which the right of self-determination is exercised in a manner that preserves international boundaries, which can be referred to as internal self-determination, or in a manner that involves a change of international boundaries, often referred to as external self-determination. In the context of colonial domination or foreign occupation, the right of self-determination can be realized through independence, association, or integration. A prolonged occupation obstructs the implementation of the right of external self-determination of a people residing in the occupied territory concerned. In regard of, amongst others, peoples under foreign or alien occupation, the General Assembly reaffirmed in Resolution 45/130, and I quote, "The legitimacy of the struggle of peoples for independence, territorial integrity, national unity, and liberation from colonial domination, apartheid, and foreign occupation by all available means, including armed struggle." Unquote. If a struggle by a people for the implementation of its right of self-determination in the context of colonial domination or foreign occupation is accompanied by the use of armed force by such people, this use of armed force must be in accordance with international law. Mr. President, I will now address the law regulating the use of force, in particular the UN Charter and its prohibition on the use of force by states, contained in Article 2, Paragraph 4. According to the Kingdom, the prohibition of the use of force is a rule of jus cogens that applies erga omnes. Indeed, in the advisory opinion on the construction of a wall, the Court confirmed that the principles as to the use of force incorporated in the UN Charter reflect customary international law. In 1966, the International Law Commission noted that the law of the UN Charter concerning the prohibition of the use of force in itself constitutes a conspicuous example of a rule of international law having the character of jus cogens. Consequently, the International Law Commission included the prohibition of aggression in its list of rules of jus cogens. One of the established exceptions to the prohibition on the use of armed force is that of the inherent right of individual or collective self-defense, if an armed attack occurs against a state, as codified in Article 51 of the UN Charter. The occupation of foreign territory can be legitimate in the exercise of the right of self-defense in response to an armed attack, provided that the use of force is exercised in accordance with the conditions attached to this right. The substantive customary conditions are necessity and proportionality. in addition to the procedural condition contained in Article 51 to notify the Security Council of the actions taken in self-defense. In the advisory opinion on the legality of the threat or use of nuclear weapons, the Court noted, inter alia, that proportionality and necessity are inherent in the very concept of self-defense. So if the placement of a territory under the control of an armed force is the result of a military operation in the exercise of the right of self-defense, necessity requires an assessment of whether the occupation and the continuation thereof is necessary to repel the armed attack or that alternative courses of action are available. This inherently supposes also a temporal element of immediacy. If the right of self-defense is not exercised relatively promptly, it may imply that the exercise of the right of self-defense was unnecessary. Furthermore, with regard to proportionality, the question is whether the occupation and the continuation thereof is proportionate in relation to the armed attack, both in qualitative and quantitative terms. If that is not the case, the occupation may be considered to violate the prohibition of the use of force. These conditions to the exercise of the right of self-defense apply as long as there is an occurring or imminent armed attack. Also, in exercising the right of self-defense, the occupying state must fully respect international law, in particular human rights and international humanitarian law. Mr. President, it is the view of the Kingdom that the right of self-defense can also be invoked in response to an armed attack by a non-state actor. This is illustrated, for example, by the Security Council's resolutions adopted after 9/11, in which the Security Council reconfirmed the right to self-defense in response to those attacks. An occupation which fulfills the requirements of the right of self-defense may be considered as lawful under jus ad bellum. An occupation which does not fulfill or no longer fulfills these requirements may lose its legal basis and hence violate the jus cogens prohibition of the use of force. Finally, the Kingdom underscores that occupation is an inherently temporary use of force, because if it were to be permanent, it would qualify as annexation. As the Security Council emphasized in 1967, in its unanimously adopted Resolution 242, the acquisition of territory by war is inadmissible. The Court recognized the customary status of the illegality of territorial acquisition resulting from the threat or use of force in the advisory opinion on the construction of a wall. Mr. President, the Kingdom now turns to international humanitarian law, or jus in bello, which regulates situations of armed conflict, including occupation. According to the Court, and I quote, "A great many rules of humanitarian law applicable in armed conflict are so fundamental to the respect of the human person and elementary considerations of humanity," end of quote, "that they are," and I quote, "to be observed by all states, whether or not they have ratified the conventions that contain them, because they constitute intransgressible principles of international customary law," end quote. In the Court's view, these rules incorporate obligations which are essentially of an erga omnes character. The Kingdom considers these principles, furthermore, to be a peremptory norm of general international law, and would like to refer in this respect to the conclusion of the International Law Commission to include the basic rules of international humanitarian law in its list of rules of jus cogens. The Kingdom submits that, while international humanitarian law is applicable in situations of occupation, international humanitarian law does not contain rules for determining whether an occupation is lawful or unlawful as such, even if breaches of the rules are serious in nature. Rather, irrespective of its legality, international humanitarian law regulates situations of occupation once such a situation has arisen in fact. As noted by the court, and I quote, "Under customary international law, territory is considered occupied when it is actually placed under the authority of the hostile army, and the occupation extends only to the territory where such authority has been established and can be exercised," unquote, as reflected in Article 42 of the Hague Regulations of 1907. As stated before, inherent in occupation is its temporary nature. Under the Hague Regulations, the occupying power shall be regarded only as administrator or usufructuary. After the Second World War, the Fourth Geneva Convention further developed the law of occupation by significantly enhancing the protection of civilians in situations of occupation. As noted by the court, the intention of the drafters of the Fourth Geneva Convention was to protect civilians who find themselves, in whatever way, in the hands of the occupying power. Furthermore, the drafters of the Fourth Geneva Convention sought to guarantee the protection of civilians in time of war, regardless of the status of the occupied territories. Once an occupation has factually occurred, the occupying power is obliged to act in accordance with the law of occupation. The occupying power has to respect and protect the civilians in the occupied territory who are regarded as protected persons. Protected persons are, inter alia, entitled in all circumstances to respect for their persons and shall at all times be treated humanely. Private property is to be respected. At the same time, such measures of control and security may be taken by the occupying power in regard to protected persons as may be necessary as a result of the war. As noted before, no sovereignty can be established over occupied territory, and occupied territory may not be annexed. In this regard, an important provision under the law of occupation is that the occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies. Under international criminal law, such transfers, directly or indirectly, by the occupying power, constitute a war crime, as reflected in the Rome Statute of the International Criminal Court. It is also prohibited to deport protected persons from the occupied territory. The Kingdom underscores that all high contracting parties to the Geneva Conventions are under an obligation to ensure respect for the Geneva Conventions with reference to Article 1 common to those conventions. As noted by the Court, and I quote, "Every state party to that convention, whether or not it is a party to a specific conflict, is under an obligation to ensure that the requirements of the instruments in question are complied with," unquote. Mr. President, in relation to international human rights law, the Kingdom would first note that this body of law continues to be applicable during situations of armed conflict, including occupation. The Court has come to this conclusion in its advisory opinions on legality of the threat or use of nuclear weapons and construction of a wall. It added, in the case concerning armed activities on the territory of the Congo, that, and I quote, "International human rights instruments are applicable in respect of acts done by a state in the exercise of its jurisdiction outside its own territory, particularly in occupied territories," end of quote. The International Law Commission has equally concluded that human rights treaties continue to apply during armed conflict in its 2011 draft articles on the effects of armed conflicts on treaties. It follows that an occupying power, for the purposes of international humanitarian law, is bound to respect, protect, and fulfill the human rights of all those within the occupied territory. The obligations owed by states under rules of universally applicable customary international human rights law are of an erga omnes character. The Court has confirmed this in the Barcelona traction case, considering that erga omnes obligations, and I quote, derive, for example, in contemporary international law from the principles and rules concerning the basic rights of the human person, unquote. According to the Court, this includes the prohibitions of genocide, slavery, and racial discrimination, as well as the prohibition of torture. Certain rules of international human rights law can moreover be characterized as peremptory norms of international law. According to the International Law Commission, this includes the prohibition of genocide, the prohibition of torture, the prohibition of slavery, and the prohibition of racial discrimination and apartheid, as well as the right of self-determination. Mr. President, both questions before the Court concern the legal consequences of ongoing violations of rules of international law. Several of these rules are, as indicated, peremptory norms of general international law. As we have stated before, all such peremptory norms are applicable erga omnes. I will now address the additional legal consequences for all states and international organizations in the event of a serious breach of such a peremptory norm. It being noted that these consequences are additional to the regular obligations arising from the commission of an internationally wrongful act. The rules on the legal consequences for states when a serious breach of a peremptory norm occurs are reflected in Articles 40, 41 and 48 of the Articles on the Responsibility of States for Internationally Wrongful Acts. The relevant provisions for states and international organizations may be found in Articles 41, 42 and 49 of the draft Articles on Responsibility of International Organizations. According to the Kingdom, these provisions reflect customary international law. These legal consequences may be divided in two categories: substantive consequences and procedural consequences. I will only address the Articles on State Responsibility in my statement. However, it is equally applicable to the draft Articles on the Responsibility of International Organizations. Article 40 of the Articles on State Responsibility defines a serious breach as a gross or systematic failure by the responsible state to fulfill its obligation under a peremptory norm. Article 41 stipulates the particular substantive consequences of such a breach, not only for the responsible state, but for the international community as a whole, including that state. In sum, states shall cooperate to bring the serious breach to an end, shall not recognize as lawful a situation created by such breach, and shall not render aid or assistance in maintaining the situation. The Court has confirmed the binding nature of the rules reflected in Article 41 in jurisdictional immunities. The Court has on multiple occasions pronounced on the legal consequences of serious breaches of norms affecting the international community as a whole. In Barcelona Traction, the Court established that obligations owed towards the international community as a whole are the concern of all states, and that, and I quote, in view of the importance of the rights involved, all states can be held to have a legal interest in their protection. They are obligations erga omnes, end of quote. The Court further confirmed these obligations in its advisory opinions on Namibia, the construction of a wall, and the separation of the Chagos archipelago. Thus, the jurisprudence of the Court supports the obligations reflected in Article 41 of the Articles on State Responsibility. The Court has also identified the obligation of non-recognition and the prohibition to render aid and assistance, and the obligation to cooperate to bring the consequences of the serious breach of a peremptory norm to an end. As to the specific implementation of these rules, the Kingdom observes the following. First, the obligation to cooperate to bring to an end the consequences of the serious breach of a peremptory norm will, in most cases, and particularly in cases concerning self-determination and decolonization, be implemented most effectively through the United Nations. However, should cooperation in the context of the United Nations fail to materialize, or should the United Nations be unable to take appropriate action, states are not relieved from their obligation to cooperate to bring the consequences of the breach to an end. In that case, they are obliged to seek cooperation through regional or bilateral fora. Second, the obligation not to recognize as lawful the situation brought about through the serious breach of a peremptory norm must take into account the exceptions to that rule as formulated by the Court in the Namibia advisory opinion. Third, the rendering of unlawful aid and assistance contrary to the prohibition thereto does not give rise to international responsibility of the aiding or assisting state for the underlying situation or internationally wrongful act, but only for its unlawful aid or assistance. Fourth, the obligation not to render aid or assistance includes an obligation not to undermine measures, including sanctions, taken by other states in their endeavor to bring to an end the serious breach of a peremptory norm. In particular, when the state undermining those measures does so knowing that its conduct contributes to the maintenance of the unlawful situation. Finally, it is our view that a serious breach of a peremptory norm entitles states, other than the injured state, to take a countermeasure against the responsible state as a legal consequence of that breach. Such resort to countermeasures by a non-injured state must be in accordance with the customary rules on countermeasures, including the conditions of proportionality and reversibility. As a final observation, it may be recalled that the Kingdom considers that all peremptory norms are applicable erga omnes. Therefore, the procedural legal consequence of a serious breach thereof is that all states and international organizations have legal standing to invoke responsibility for such a breach. They may claim cessation of continuing internationally wrongful acts, assurances and guarantees of non-repetition, and performance of the obligation of reparation. A claim concerning reparation is restricted in the sense that it must be in the interest of the injured state or international organization or of the beneficiaries of the obligation breached. And such beneficiaries may include individuals and peoples. Mr. President, this brings me to the end of my statement. We sincerely hope that your advice will contribute to achieving peace in the Middle East. Thank you, Mr. President.